Hi there, my name is Conor O'Mahony. I'm a senior lecturer in the School of Law in UCC, and every year I teach our first year students about fundamental rights under the Irish Constitution. So, in this video, I'm just going to give a very quick 10-minute taster of what it is we study in that module. In looking at the Irish Constitution, I teach about the rights which we have as Irish citizens. So that is, what freedoms do we have to conduct our lives in the way that we see fit without interference from the state, or what entitlements might we expect to have provided for us by the state, and how can we challenge the state in the event that the state takes action or fails to take action in a way that fails to vindicate the constitutional rights that we have. So the module involves examining what are the rights that are protected by the Constitution, what's the scope of those rights, how far do they go and what do they cover, what limits apply to the exercise of those rights, and what powers do the courts have to step in and protect those rights for us in a case where the state fails to vindicate those rights. At the moment, we're seeing a very good illustration of all of this in the context of the Covid-19 crisis and the emergency measures which have been put in place by the state. They're a very good test case for what a constitutional dispute often looks like. So the Covid-19 restrictions, if you were a lawyer and someone who was unhappy with those restrictions were to come to you and say, I would like to challenge those, the first thing you would have to do would be to identify what rights are being limited. So looking at those restrictions, they include measures which prevent people from moving around freely, which close businesses, which prevent people from going to work. And there are measures which also allow for the detention of people in the event that somebody is infected with COVID and fails or refuses to isolate themselves to prevent the spread of the disease. So the rights which are at play there, the Irish Constitution protects rights including the right of freedom of movement within the state, the freedom to travel abroad. It also protects the right to work without undue state interference. And it protects a right to personal liberty and a right to due process of law. In other words, that you won't be deprived of your liberty and detained ordinarily without a very detailed court process leading up to that point. Now, obviously, the COVID-19 restrictions limit in some way all of those rights. But one of the key things that arises in constitutional disputes is that rights which are protected by the Constitution are not absolute. Rights are almost always open to some level of legitimate state interference and limitation. And so the disputes very often centre around the question of how far can the state go before a particular restriction on a right becomes illegitimate and therefore unconstitutional. So again, if a client were to come to you and say, I want to challenge those laws, your first step is to identify what rights have been limited. But your second step then would be to try and anticipate what might the state argue in response in seeking to defend or stand over the laws which it has passed. And again, in this case, there are quite legitimate arguments that can be made by the state as to why those rights are legitimate and constitutional. So the obvious thing the state would point to is that the COVID-19 restrictions, while they obviously limit the rights of some people, they are also designed to protect the rights of others. Most obviously, you have the right to life and the right to health. So if COVID-19 is allowed to spread without any mitigating measures, then obviously a lot more people are going to die and a lot more people are going to get sick. And so essentially what the state has done is it has decided that the right to life and the right to health of people who may be affected by the disease should be given a very strong degree of priority over the other rights which I've already mentioned. So that's what the state would argue in response. The third thing you would then have to do in advising your client would be to try and anticipate how might the courts weigh up those competing arguments and which one of them is likely to prevail. And in doing that, you would have to look to similar cases which have been before the Irish courts in the past and try to draw analogies between those cases and the case which you might be taking. So one case which presents a good analogy in this context is a case from 2013 called Fleming versus Ireland, and that was a case involving our assisted suicides law. So Irish law makes it a criminal offence for you to assist somebody to commit suicide, even if that person has made a very conscious and free decision that they want to commit suicide. Mary Fleming was a long-term sufferer of multiple sclerosis. She was essentially facing a very long and slow, painful death. She wanted to end her life at a time of her own choosing, but needed the assistance of her partner to do so. But that would have exposed him to potentially very serious criminal liability. So she went to court and argued that this particular law was a violation of her right to personal autonomy under the Irish Constitution, which is a recognised right. But again, the state argued that while this right may have been at issue, that the laws in question were necessary in order to protect the right to life of potentially vulnerable people who perhaps might feel pressured into assisted suicide in cases where they might otherwise have chosen not to. And so therefore, ultimately, the court found that that particular law was constitutional. But also, and importantly, the court found that making a decision in that case on this sensitive social policy issue and deciding how to balance the competing rights which were at issue was really a decision to be taken by the Oireachtas rather than by the courts. And this is a very common theme in constitutional law. When it comes to issues like this, there is the question of who should decide on these big, important, fundamental questions which face our society. Should those decisions be taken by the courts, or should they be taken by our elected representatives in the Oireachtas? Now, there isn't a one-size-fits-all answer to that question, but what we're increasingly seeing in recent years before the Irish courts is that when cases of this nature come to court, the courts tend to defer to the judgment made by the Oireachtas in an awful lot of cases, and the courts tend to be very slow to step in and override a decision taken by the Oireachtas on the ground that it is unconstitutional. So whenever there is an issue of sensitive social policy, or whenever it is a case of competing rights and deciding which of those competing rights should be given priority, we tend to see the courts taking a very cautious approach and being quite reluctant to invalidate laws of this nature. Fleming is a good example of that. We've seen a similar tendency in other cases around issues like, for example, surrogacy laws, like the law governing statutory rape, and also various emergency measures taken during the financial crisis from 2008 onwards. So all told, if you were a lawyer advising your client in a case like this, you would identify that yes, there is an arguable case that could be made that you do have constitutional rights which are being limited by the Covid-19 regulations. At the same time, those regulations are designed to protect other competing constitutional rights, so the state would certainly be able to mount a very strong defence of those laws. And as to which way the court is likely to go, it would seem that if you were to take a challenge of that nature, you would have something of an uphill struggle. It would be difficult for you to succeed in striking down the Covid-19 restrictions. But that's not to say it is impossible, because one of the things we find in constitutional law is that while you try to anticipate when laws are being drafted every possible scenario, sometimes individual cases can come up which perhaps have a harsher impact than might have been anticipated when the particular laws were being drafted. And so sometimes individual cases can shed new light on a situation that wasn't originally apparent. And so therefore it's not impossible that laws of that nature might be struck down. But having said that, I do think the recent trends demonstrate that the Irish courts might be quite reluctant to do so. So that's a little taster of the kind of issues that we deal with in studying constitutional law. And there are lots of other examples. We go through a whole range of cases looking at issues like family rights, like the right to education, like equality law. And it's really a course which involves an awful lot of sort of hot topics, an awful lot of issues on which people tend to have very strong opinions. And therefore, it's a course which I think a lot of students find to be one of the courses they really enjoy in the course of studying a law degree, because it tends to be about issues that they already care about and perhaps already have a strong view on. So if you do choose to study law in UCC, then I would really look forward to teaching you that material when you were in first year. Thank you very much for listening.